Hi, good morning or afternoon, everyone, and thank you for joining us for our webinar today, Keeping Up with the Supreme Court. My name is Susan Parnas-Frederick, and I will be your moderator. I am the Senior Federal Affairs Counsel for NCSL, and I work in our Washington, D.C. office. Before I introduce our speaker for this session, I'd like to take just a minute to explain NCSL's Supreme Court involvement. NCSL, along with the 6 other national associations that represent state and local elected officials, enlist the services of the State and Local Legal Center. The 6 other associations are the National Governors Association, the National Association of Counties, the National League of Cities, the United States Conference of Mayors, the Council for State Governments, and the International City County Managers Association. The State and Local Legal Center procures and oversees pro bono counsel to write amicus briefs on behalf of NCSL and these 6 other national associations in U.S. Supreme Court cases that have significant state or local government impact. Depending on the cases accepted by the court, depends on the number, will I guess, guarantee or dictate how many briefs we actually file to the Supreme Court. The State and Local Legal Center also provides many opportunities to learn about these cases and more through additional webinars and in-person meetings. For example, NCSL brings our speaker to every in-person meeting to brief our members on the Supreme Court's current term, on the state cases of great import, as well as the inner machinations of the Supreme Court. And our members really love that piece of what Lisa tells them. They feel like they're kind of inside the Beltway scuttlebutt. So it's very, very entertaining and very informative. We learn about how the justices respond to certain cases, trends in the court, and even predictions on the types of cases the court might hear in their next term. So with all of that buildup, I'm going to now introduce our world famous speaker, Lisa Sorensen, who is the executive director for the State and Local Legal Center. Prior to joining the SLLC, Lisa worked for the National School Boards Association, the Wisconsin Association of School Boards, and clerked for the Wisconsin Court of Appeals. So she's a very seasoned attorney. She earned her JD at the University of Wisconsin Law School and is a graduate of Central Michigan University. As we go through the presentation, if you have any questions about the cases, and I know there's probably a lot, or the court in general, please put them in the chat and we will get to them at the end of the presentation. So without further ado, I'm going to turn the program over to Lisa.
Thank you, Susan. So first and foremost, congratulations to all of you for being elected to be state legislators. I think you'll find the position enjoying and challenging, and there's lots of great opportunities to learn through NCSL. So what I'm going to talk to you today is about how the Supreme Court matters to states, and in particular matters to you in your new role as a state legislator. I'm also going to talk about the seismic shifts really that are happening on the Supreme Court as we speak. And then I'm going to talk about a couple of cases of interest to states that are on the docket or have been recently decided. So this is my first time ever talking exclusively to new state legislators. And every time I give a presentation that's long, I try to tell people, if it's appropriate for me to say this, like, this is the most important point I'm going to make in my presentation. And for this conversation, this is my most important point to you. The Supreme Court really does matter to state legislatures and will affect your work as a state legislator. So it's a body for you to keep your eyes on at all times. Now, with that said, in reality, the court is a rather obscure branch of the federal government. It's 9 unelected people who are relatively homogeneous, not average, and never young, though I keep on changing my definition of young. In fact, you might be interested to know a recent CNN poll showed that half of the people surveyed could not name one Supreme Court justice. So with that, I'm going to turn to my first polling question. You can find question 1 at the bottom of your video player. And the question is, how many Supreme Court justices are you able to name? Just give a good guess. The reality is this, even though the Supreme Court is quite obscure, it's often deciding some of the most important issues of the day. If you look at this slide, for example, you'll see all the things that the Supreme Court has done in the last 10 years. I used to keep Citizens United just on one side by itself, but I added the fact that it didn't overturn the 2020 election, which of course, some people speculated that it might. But the court has done, just very significant things that affect everyday Americans' lives and states as well. Susan, do we have any poll results?
Yes, we do. So let's see. Nobody said they couldn't name any, which that's good news, right? It's pretty split between 5 to 7 and 7 to 9. So you guys aren't doing too badly.
5 to 7 is more than respectable. So in terms of who the Supreme Court hears cases on, the reality is the biggest darling to the Supreme Court is states. I would say 2/3 of the cases that the court takes involve states in some way or another. And these cases can be big, they can be small, they can be boring, they can be interesting. Bankruptcy and patent cases don't generally affect the states, but short of that, almost everything else does. And here's the most important point for you in terms of how this is going to affect your role as a state legislator. So I would say about 5 cases every term, the Supreme Court is tackling state legislation directly. The court might be interpreting it, might be preempting it, or not preempting it as the case may be, and might be just declaring it constitutional or not unconstitutional. When the court does any of those things, sometimes you have to go back as state legislators and change laws, or maybe you'll be allowed to legislate in an area you didn't think you could before. So that's the big sort of practical impact. So now I'm going to move to the second part of my presentation, which is to just talk about the shift that's been going on in the Supreme Court. So the Supreme Court in the last 6 months, really the last 3 months, has gone from a 5-4 conservative court with an increasingly moderate Chief Justice to a 6-3 conservative court where the Chief Justice's vote will no longer matter. I want to point out to you that a lot of people thought that Justice Ginsburg would live to be replaced by a more liberal justice, and that Chief Justice might, for the next decade, remain in the center of the court. That has not happened, and it's not going to be what's going on in the near future. So I'm going to cover a quick timeline on what went on in the last couple of months. So at the middle of last summer, all eyes were on the Chief Justice. The Supreme Court had a bevy of controversial cases. If you look at the words in bold, just the words, it would normally take the court an entire decade to hear cases on all these controversial subjects, but nevertheless, they heard them in one term. So last term was supposed to be the first term where we had 5 real conservative justices, meaning Chief Justice Roberts and the other sort of more traditional conservative justices. In theory, last term, gone was the unreliable justice. That was, of course, Justice Kennedy. So really, since I was born, we've had one unreliable conservative justice. The most famous one is, of course, Justice O'Connor, but the most recent one is Justice Kennedy. He sat in the middle of the court for 10 years, voting sometimes with the liberals, sometimes with the conservatives, more often with the liberals on social issues. But it looked like now Roberts was going to be in the middle and he was going to be a solid conservative, or so most people thought, certainly not everyone. So I want to just make one point as well before describing what happened. It's important to realize this. Most Supreme Court cases are not decided 5-4, and they're not even decided on ideological lines. In fact, about half of the court's docket is actually decided 9-0. And the 5-4 decisions tend to be about 20% of the docket, and only half of those are even in controversial cases. But when I reflect on the last 10 years, I can only think of 2 big controversial cases that weren't 5-4. So that 5-4 has really made a difference in the last 10 years. So what did Chief Justice Roberts do last term? Well, he joined the liberals in a number of cases listed on this slide. It's not just possible, but probable that his going left last term was sort of overstated. And I'm at least part of the problem. My friend Adam Liptek at the New York Times points out, like, there was a lot of controversial cases last term. And really what the chief did was he doled out victories to the right and to the left. But when he doled out a victory to the right, that really didn't make the news because that's what people expect. So when he voted with the left, it got a lot of attention. And he did a couple of times, but mostly in sneaky sort of ways. So the theory that most people believe, myself included, is that why the chief has voted with the liberals at least a few times is that he cares about the court as an institution. He's worried about the court looking too political. There are current, or at the time, 6 months ago, there were 5 justices who were appointed by conservative presidents, 4 by liberal presidents. So if all the justices vote along the lines of the president that appointed them, they look fairly political, fairly ideological. So Chief Justice Roberts was trying to avoid that. Now, people push back and say, well, if he's changing his vote to not look political, isn't that political? And I think that point is well taken as well. But here's the thing. I don't think the purpose of the Supreme Court is to necessarily be 100% in lockstep with public opinion. But certainly, if the Supreme Court's reputation was very poor and most Americans disagreed with what it was doing, the institution wouldn't be considered very successful. Look at these Gallup poll numbers. They are incredible. Can you imagine Congress getting a 58% approval rating? Can you imagine Congress getting half of that approval rating? And look at the number of Democrats who approved of the Supreme Court. Now, granted, part of the reason why they may have approved of the court was because they were worried Roberts was going to be more conservative than he turned out to be. But regardless, those numbers are absolutely incredible. So the next thing that happened was Justice Ginsburg died. This is a very significant event, and I'm going to talk about what it means from a number of different perspectives. So I'm going to start with another polling question. So you can see this question on the bottom again of your screen. And this question is, how many of you have seen the documentary that came out maybe 2 years ago about Justice Ginsburg and the Hollywood movie that came out around the same time? So while you're answering that question, I will say that I saw both movies. And even though I work with the Supreme Court and work on Supreme Court matters, I knew Justice Ginsburg was a feminist. I knew she had done a lot of incredible things in her lifetime. I did not realize that she had argued 6 gender discrimination cases before the Supreme Court, which is quite an accomplishment. And no matter how you feel about her, it's amazing to have a cultural icon who was a Supreme Court justice. So Susan, let's see if our audience are big moviegoers.
Well, it looks like about half of our audience has watched the RBG documentary, and half of them have not seen either movie. So I will say I watched the RBG documentary. It was really good. You should watch it.
Yeah, they're both good ones. And I actually think there's another one coming out as well. So I want to talk for a second about Justice Ginsburg for states. So all justices are a mixed bag. But what I think many people didn't appreciate about Justice Ginsburg is that she really was very much a pragmatist who wanted fairness and common sense to prevail, especially in the lower profile cases where being a liberal didn't necessarily matter. So you're new to this role as a state legislator, but any seasoned state legislator knows about South Dakota versus Wayfair. If it's the only Supreme Court case, they know about it. So basically, before this Supreme Court case, the court had held that if you had a business and you were physically not present in a particular state, you didn't have to collect sales tax. So if you were Amazon and you had a warehouse in Maryland, but you served all of Northern Virginia, you would not have had to collect taxes in Virginia unless you had a warehouse. So states were losing all kinds of tax revenue. So a case came to the Supreme Court asking the Supreme Court to overturn precedent and rule that basically if you have a significant nexus or connection to a state, you have to collect sales tax whether you have a warehouse or not. And that's what the Supreme Court in fact ruled. So it was a 5-4 decision, and Justice Ginsburg joined the other conservative justices except Justice Roberts. And so you might find that kind of interesting and odd. Why did she do that? Well, here we don't know, but here what was going on in the background. Justice Kennedy was retiring. This was making many liberals nervous to think, oh no, Roe versus Wade is going to get overturned. So the liberal justice, as the theory goes, didn't want to join the conservatives in South Dakota versus Wayfair because it involved overturning precedent. But Justice Ginsburg, I think, being a pragmatist, was like, this has nothing to do with Roe versus Wade. This precedent is terrible, and we need to get rid of it. And I think it does, like I said, this case kind of illustrates her pragmatism and her common sense beyond the thing that she's most famous for being liberal. So like I said at the beginning of the presentation, how her death affects the court is that the court will move slightly but firmly to the right, as Adam Liptak has said, making compromise less likely. Only slightly because remember, the court was pretty conservative before. So now the justice at the center will be Justice Kavanaugh, and we still don't really know a ton about him. Now, I know there are definitely some liberals listening in to this conversation. And some of you have been probably very upset by the changes and concerned. I still think there's some hope for liberals here, and I'll tell you what it is. Roberts, Gorsuch, Kavanaugh, and Barrett will never, ever, ever be true liberal justices. I don't think anyone believes that. But Justice Roberts so far has been able to pick off Justice Gorsuch in one case where Justice Gorsuch, what was a big case that Justice Gorsuch also voted with the left. And he's going to pick off Justice Kavanaugh in the Ncaa case, which I'm going to talk about later. And he might be able to pick off Justice Barrett here or there. These conservative justices, they're not monoliths. They don't share all the exact same views. And I think some of them will have the same institutional concerns that Justice Roberts will. And so I think there's a possibility that every so often, Justice Roberts will be able to pick off one of an ever-changing arrangement of his colleagues that doesn't include Justice Alito or Justice Thomas. So what this meant for the Supreme Court was, have no illusions about this. Justice Roberts is a conservative, but what he wants and what he wanted, I think, was to have the court move slowly in a more conservative direction. He no longer will be in charge of the pace at which the court moves conservative, if it does, because he will be the sixth justice, if you will. So in November of 2020, Justice Barrett joined the bench. She has all the hallmarks of being a traditional conservative. Unlike Kavanaugh and Gorsuch, though, the other recent appointees, she doesn't have a long appellate record. She's also very different than the justices on the bench because she's not an Ivy League East Coaster who work for the federal government. Most of the Supreme Court justices meet all three of that criteria. So she's going to make a difference, I think, in some of the areas where Justice Roberts held back. Guns is one area in particular. I would expect in the next 2 years to have a ruling that you have a right to a gun outside your home per the federal Constitution. That's what I'm expecting. And the court hasn't accepted a gun case yet, but I think it's pretty inevitable. The other thing is Justice Barrett has already made a difference on the court. And this is actually very odd. So she's been on the court for 3 months. The court's issued a couple of opinions. She hasn't participated, as far as I know, in any of them. But the court has this thing called the shadow docket where they're deciding kind of emergency motions. And a bunch of them have involved stay-at-home orders. Parties, mostly churches, have come and said, this stay-at-home order discriminates against religion. We're not able to meet in the same way as other similar activities. Before Justice Barrett joined the court, the states won all those cases. Now the churches have won all the cases. Some of them would have come out the same even if Justice Ginsburg was still on the bench. But it is an interesting place where she's already made a difference. And part of the reason she was controversial was because of her conservative religious views. So it's kind of interesting that she's first made an impact in religion. Another thing I want to point out is that the next thing on our timeline is the election. And the Supreme Court, like I said, did not decide the 2020 election, but it has some involvement in it. And a lot of that involvement might have gone unnoticed because it was on this shadow docket where the court was just deciding emergency motions, but it's very relevant to states. So a number of states decided that they were going to count ballots received after the election. And the court heard challenges to these decisions. And the court went different ways. In Wisconsin, the court said, nope, these late arriving ballots can't be counted. In North Carolina and Pennsylvania, the court said, yep, the late arriving ballots can be counted. What was the difference? The difference was in North Carolina and Pennsylvania, it was a state court judge applying the state constitution who said, it's okay to count late arriving ballots. Now, imagine those late arriving ballots had made a difference in the election. They didn't, but imagine they did. What did Roberts just do? He used a conservative states' rights strategy and a judicially modest approach to deciding these cases, 2 of which benefited Democrats and 1 of which benefited Republicans. It was absolutely brilliant strategy, just slicing the baby as the case may be. And it may be the last time we see him kind of controlling the strategy and the direction of the court in that 5-4 sort of way. So now we're going to move on to January of 2021. President Trump left office after appointing 3 Supreme Court justices. And Joan Biskupic wrote a great article about this in CNN, and I completely agree with it. If you look at, President Trump complained a lot about the Supreme Court, but in reality, the Supreme Court gave President Trump what he wanted more often than not by a pretty large margin. But if there was one individual, one person on any institution, the court, in his family, in Congress, Who stood in President Trump's way? Was Chief Justice Roberts. And I have a couple examples on this slide where he sort of was a check to the president. But overall, the Supreme Court was quite good to President Trump. So here's the question that you all might be wondering about. Now that we almost for sure have this solidly conservative Supreme Court almost all the time, what does that mean? It actually might mean less than you think. And part of that is that when I talk about this 5-4 court, I'm really talking about it in these blockbuster cases. But the majority of cases of interest to states aren't blockbuster cases. They're not decided 5-4, and they're not decided on ideological grounds. And actually, it's kind of funny because if you'd ask me what my ideal Supreme Court justice is for state governments, in this order, it would be a pragmatic, moderate, conservative. That's probably Chief Justice Roberts. So like I said, for states, the impact might be not exactly what you think. So now I'm going to talk about the cases. So this is going to be the balance of my presentation. And I'm going to talk about the cases a little bit differently than I normally do. I'm going to introduce each case by talking about what it illustrates about the Supreme Court and what it illustrates about states. If you're a legislator for a long time and you go to a lot of presentations and you learn a lot about the Supreme Court, you'll see trends over and over again. You'll see patterns repeat. And I'm not just talking about in the law, but I'm talking about in the kind of cases the court takes, in the dramas that the cases sort of set up, but you don't have enough context to know that going in. So I'm going to explain some of that context to you now. So the first case I'm going to talk about is the most inevitable case for me to talk about of all, which is the Affordable Care Act case. This is probably the only real and true blockbuster the Supreme Court will decide this term. I don't know that it'll be decided 5-4, but it's kind of a 5-4 kind of case. And it's not going to be decided the way that most people think. The other thing that's really important to know is this. The federal government did not defend the law in this case. So this case is actually a dispute between two states, California and Texas, and other states sort of in the middle. So for those of you who haven't lived and breathed the ACA for the last 10 years, which I certainly have. So basically there was this individual mandate. There still is an individual mandate. If you didn't buy health insurance, you had to pay what was called a shared responsibility payment. In 2012, the Supreme Court said that shared responsibility payment is constitutional because it's a tax. You're essentially paying a tax to the federal government. Well, Congress made that shared responsibility payment zero. So how can you be taxed if you don't have to pay any money? That's the question, right? So it seems pretty obvious that no tax exists anymore. So the case comes down to this concept called severability. It's the idea, if part of a law is unconstitutional, can the rest of the law stand? And the law favors severability, meaning the law favors that if part of the law is unconstitutional, the rest of the law just sort of stands. So what happened at oral argument was you had the Chief Justice and Justice Kavanaugh both saying, kind of under no uncertain terms, we think this law is severable and that the rest of it should stand. So you might remember on the news, Chuck Schumer wringing his hands over Justice Barrett and me rolling my eyes in the background. Well, maybe you didn't see that part. I predicted that this is sort of how this case would go because last term in two separate opinions, the Chief Justice and Justice Kavanaugh wrote opinions that were essentially love letters to severability, kind of indicating how they would vote in this case. So I told you at the outset that the Trump administration did not defend the law in this case. The Biden administration has written a letter saying, oh, by the way, we do defend this law. Not only do we think it's constitutional, even if it's not constitutional, it should still be severable. So this isn't a case to keep your eye on, but I think it's going to come out probably the way I predict. There's other cases on here. I couldn't begin to predict how they turn out even after oral argument. So the next case I'm going to talk about is U versus P. It actually is a longer name, but it's not worth it to watch me try to pronounce it correctly. I bring up this case in particular because NCSL joined the brief in this case. And this case also illustrates another point I've been making sort of about the Supreme Court. This is not a liberal versus conservative case. This one won't come out 5-4 with conservatives on one side and liberals on the other. Also, this kind of case represents what the Supreme Court's docket is typically made of. The docket, like I said, not typically made of controversial cases. It's made of cases that have so-called circuit splits. That's where one federal circuit decides an issue one way and another federal circuit decides it another way. So this case is just a good example of this. So the question in this case is if a government changes its policy after a lawsuit has been filed, is the case moot if the plaintiffs only ask for nominal damages. Nominal damages are like asking for $1. This college basically had a totally and completely unconstitutional materials distribution policy. 2 students sued, and the university changed its policy. All the students asked for is for $1, but they could have asked for more. They could have asked for like gas money or bus fare to go and distribute their materials at the school, but they didn't. The lower court said, you know, they changed their policy. You got all you want. You don't get any more. The case is over. The students said, well, but we're poor students. Like, we graduated. Universities change policies all the time. Like, this means our case will never be decided. So you might just say, well, why didn't the university just agree to pay the $1? Well, by agreeing to pay the $1, the university might be having a judgment against it. And judgments affect a university's reputation, can affect the financial statements, and they can also establish a pattern of practice, which can lead to other sorts of lawsuits. The other thing is this case kind of happens in a larger context. In this case, like I said, the policy was 100% unconstitutional. But oftentimes groups will come in, particularly the local governments, and they'll sue over policy that may or may not be constitutional. And the local government will just throw its hands up and say, we can't afford for this lawsuit, we'll just agree to the policy changes you want. But they don't want to admit they violated the law because maybe they didn't because the law was unclear. So anyway, that's a good case that shows, you know, NCSL's involvement in a case trying to reduce frivolous lawsuits or unnecessary lawsuits against states. So next case I'm going to talk about is Rutledge. This is a preemption case. Preemption cases, I think, are basically unique to the states, and maybe local governments in some ways as well. Preemption cases almost always, but I don't think always, involve state legislation. The court decides a preemption case every other term. Sometimes it might decide them more often. Some are big, some are small. And here's the other thing. Almost every single one of you are from a state that has state legislation on this topic, which is pharmacy benefit managers, which gets me to my next polling question. And I'm dying to see the results of this. Before I said the magic words to you, pharmacy benefit managers, how many of you had heard about that term? So go ahead and answer the polling question, which is down on the bottom of your screen. I'm going to give you guys a second to answer this question because I don't want to explain what pharmacy benefit managers are if you don't know while you're trying to answer the question. Okay, Susan, do you have results or is it too soon?
We're still logging them in.
Okay.
It's another second or two here. Oh, wow. It looks like most people do know what pharmacy benefit managers are, well, but there's 30% of them that don't. So maybe explain for that group.
So I have to say, I am super impressed that about 70% of you know what pharmacy benefit managers are. I mean, that shows that you are ready for your job as a state legislator. I had never heard of them until I read this case for the first time about a year ago. So basically, here's the long and the short of it. When you go and fill a prescription at your pharmacy, probably if the 30% of you think probably what I do, which is that your health insurance company pays whatever you pay that isn't the copay, okay? But that's not what happens. What actually happens is if a pharmacy benefit manager is involved, and most of the time they pay the drug insurance costs, and then they go after your health insurance company, and your health insurance company reimburses them. So the controversy in this case was that Arkansas passed a law saying that pharmacy benefit managers had to pay for, they had to pay the pharmacy at least the cost that the pharmacy bought the drug at. Arkansas said pharmacy benefit managers, they're refusing to pay the cost of a drug, and so pharmacies are going out of business. So the question in this case was whether or not this Arkansas regulation that regulated the cost of drugs that pharmacy benefit managers have to pay is preempted by Erisa. It was an 8-0 decision by Justice Sotomayor. So for those of you who aren't familiar with Erisa, it's a law that basically talks about the fiduciary duty for health insurance and retirement plans and what information has to be provided. So it doesn't require specific things of plans necessarily. It's more information gathering, fiduciary, that kind of thing. So Erisa preempts state laws related to Erisa plans. A plan is related to Erisa plan if it is connected with an Erisa plan or it has a reference to the plan. The Supreme Court said this regulation isn't connected to an ERISA plan because it's a cost regulation. It has nothing to do with fiduciary duty or reporting data or anything like that. The court then went on to say there's no impermissible reference to ERISA because pharmacy benefit managers can be involved in ERISA plans and non-ERISA plans. So let's say I bought health insurance on the exchange. ERISA doesn't come into play, but a pharmacy benefit manager still could. So that's a case. The significance of this case is had the court gone the other way, many of you in Arkansas, or many of you would have had to change your pharmacy benefit manager laws because the court would have said they were preempted. So the next case I'm going to talk about is the Medicaid case. This is a great case where states' rights meets politics. You may very well love the idea of states' rights, but not like so much the policy behind this Medicaid case. The other thing is this case has everything to do with the fourth branch of government. I'm not sure I even heard the term fourth branch of government until I went to law school. This is, of course, the administrative state. So this is states' rights versus sort of the administrative state. The other thing that this case illustrates is we just had a change in administration. And a lot of President Trump's policies are currently being litigated as we speak, but President Biden wants different policies. And that comes to bear and comes to play in this case, which I'll talk about at the end. So the issue in this case is whether or not Medicaid work requirements are lawful. So 12 states have approved Medicaid work requirements, 7 are awaiting approval, and California has said we will never have Medicaid work requirements in our state. So basically when Medicaid was expanded, most states I think at this point have taken the expansion, though certainly not all. Low-income adults were covered, not just blind people or the elderly or those with dependent children. So a couple of states have said if you want to get Medicaid, you have to either work part-time or at least try to work part-time. The question is, does this violate the this came out of an Medicaid agency came up with this rule, CMS or HHS, I'm not sure which one. So the question is, this is just a federal agency, this isn't Congress. Is what they're doing violating the Administrative Procedures Act, which says that federal agencies can't act in an arbitrary and capricious manner. So essentially, is making Medicaid recipients work or look for a job arbitrary and capricious? The DC Circuit said yes. The DC Circuit said the point of Medicaid is that people get health insurance. When you make them get a job, many of them are going to get kicked off health insurance. And it actually turned out about 25% of Medicaid recipients in Arkansas were in fact kicked off of health insurance as a result of this requirement. So here's like what I said, where the president and the new president and the old president kind of meet up at the Supreme Court, if you will. The Solicitor General, Biden's Solicitor General, so Biden's #1 Supreme Court lawyer has said, look, this case is moot. Biden is going to take these Medicaid waivers away. Arkansas says, well, you haven't taken them away yet, have you? You're just, doing the steps. You're rescinding policies, but you haven't literally taken my Medicaid waiver away. So, so that's what that case is about. Another very interesting one. I can't say whether or not I think the court will say this is moot. They're supposed to hear the case in March, so they've got to make a decision really soon. So for an audience like this, I normally wouldn't talk about the New Jersey pipeline case because it's a little bit on the obscure side. But this is like the ultimate states' rights case that has nothing to do with state legislation and not anything really to do with state policy. State policy is maybe in the background, but this is good illustration of the Supreme Court and states' rights where there's no legislation at issue. So the question in the case is whether or not a private natural gas company may use the federal government's eminent domain power to condemn state land. So the National Gas Act authorizes private companies, like the company in this case, Penn East, to get land by eminent domain to build a pipeline. So Penn East went to New Jersey and said, we want to take 42 plots of land. And actually, let me clarify. Penn East took New Jersey to court saying, we are going to take 42 pieces of your property. New Jersey responded by saying, oh, there's this pesky thing called the 11th Amendment. And we have not consented to be sued by a private company over an eminent domain matter. The federal government, there's an exception to the 11th Amendment. The federal government can sue state governments over anything. But New Jersey said the federal government can't sort of pass along its right for eminent domain to get to a private company who can then sue it in federal court. All this to say that the Third Circuit agreed with New Jersey and said that that the federal government is not allowed to pass along its eminent domain power to a third party, New Jersey, that can't be sued in federal court. So what's at stake in this case? It's kind of hard for me to, on a practical matter, it's kind of hard for me to say, because here's the deal. It's very clear that the federal government could just go and do eminent domain itself. And New Jersey couldn't claim that the federal government couldn't bring it into court. The federal government can always bring New Jersey into court. So why didn't the federal government just do that? Why did it give the authority to Penn East? Well, Penn East says the federal government doesn't have its own independent authority to condemn property. But the Third Circuit said, how can that possibly make sense? Like, you, Penn East, want us to delegate the federal government's authority to you, but you're saying the federal government doesn't have the authority to do the eminent domain itself? So it's kind of an interesting and tricky case, but you can see the state angle of New Jersey saying, like, we don't want some private companies suing us in federal court that we haven't agreed to be sued by. So what's interesting about this case as well is that the Trump administration supported Penn East. I expect the Biden administration to do the same. For the Biden administration and for any president, really, this case is going to be about executive power versus states' rights. The other thing, too, is think about this. The Biden administration might want other laws, not just the Natural Gas Act, but let's say the Wind Generator Act or the Solar Power Act, to also have an eminent domain provision that private parties can rely on. So President Biden might have another interest in this case as well. So the Cedar Point Nursery case, there's a couple reasons to discuss this case. The first one is that it involves state legislation, but so did the Rutledge case. It's also a case about unintended consequences, but that's not why I bring it up. I bring this case up because it's a complete and total sleeper. But if the Supreme Court rules against states, it will have a huge impact on states, but most people won't care. States will care anyway. So my husband is a consultant, and he always criticizes me for having too many words on my PowerPoints and not enough pictures. So this is my daughter, Simone, and my dog, Stinky Stella. So this is a hypothetical I want you to imagine. One day, I'm at home, and a police officer knocks on my door and says, your neighbor called because your dog won't stop barking. And I say to the police officer, oh, I didn't realize she was outside. And so I let the dog in, and I give a bill to the police officer and say, you came on my land, you're going to pay me for a temporary easement for being on my land. That is the situation that this case presents in a most unusual way. So the legal issue is a temporary easement, the government temporarily allowing someone to go on someone else's land, a taking. And here's the deal, having 6 conservatives who are going to be very pro-property rights, it's going to be hard for state and local governments to win this one. So I'm going to give you some background if you haven't thought about takings since law school, or you didn't go to law school, or you've never thought about takings. The Fifth Amendment allows the government to take property, but the government has to offer just compensation. There are 3 categories of taking. One is a per se taking, but the Supreme Court said to have a per se taking, the taking has to be permanent. So the question is this a permanent taking in this case? So here's the background. Like I said, it's kind of crazy. So California has this law that basically says that unions can go to agricultural employers 3 months out of the year and spend multiple hours a day on those properties trying to unionize workers. Like I said, the law was passed in 75. I think it was designed specifically for California's Central Valley. It's still the case that agricultural workers in the United States live on their employer's property. I guess it's not the case for the nursery at issue in this case, but that still does happen. But anyway, that is the law. So the nurseries say, this is a taking. I mean, if these union people can be at my workplace 3 months out of the year, 5 hours a day, like how is this not a taking? The Ninth Circuit said this isn't a taking because it's not permanent. And they gave an example of a case I talked a lot about in law school, which was Nolan, where this guy built a big beach house. And the county said, you can build the beach house, but you have to give an easement so people can get to the beach from your house. And the Supreme Court said that's a permanent invasion because 24 hours a day, 365 days out of the year, 7 days a week, people could go to the beach going on your house. So the Ninth Circuit said that this isn't that scenario. The unions can't come all the time. So here's the deal. If the Supreme Court says, look, if union organizers going on private property for a couple months at a time is a taking, state, even though it's temporary, state and local governments coming on my property to tell me to shut my dog up, that's a taking as well. If you sort of think about it logically. I actually think there's an easier sort of way out of this case. I think the Supreme Court could say, we're not going to decide what a temporary taking is. We're just going to say that this is a permanent taking. I mean, if you're really on someone's land for 90 days out of the year for 5 hours, that's a permanent taking. It's not the same as knocking on my door and telling my dog to shut up and leaving. I think that's how the court might come down on this case. But if they don't, this case will be a big deal for state legislatures. So the Ncaa case, why talk about this case? So the Supreme Court usually takes, I would say, 2 cases a term that are of interest to pop culture, that any American might have some knowledge of, might have some curiosity about. Usually these tend to be the bigger cases, and so they affect state legislatures. The Ncaa case is no exception. It is one of those pop culture cases that your average American cares about that also impact state legislatures. So as you all know, the players in the Ncaa are amateurs. So they're not paid a salary, but they can be given what I would think as fairly generous, reasonable academic and athletic expense payments. But the students have said those payments aren't enough. Like, we want to actually be paid. We don't want to just get, $1 here and $1 there for tuition. So the question is whether or not the NCAA's refusal to allow students to be paid sort of a regular wage violates antitrust law. So antitrust law is kind of complicated. There's a law called the rule of reason, which applies to it. I won't go into all the details, but basically the Ninth Circuit ruled in favor of the students. And what the Ninth Circuit said is, it would be one thing, Ncaa, to give these students salaries as high as like NBA players. But it's another thing for you to be so stingy about reasonable and necessary academic and athletic expenses. You could give student athletes way more generous, reasonable, necessary athletic and academic expenses without truly jeopardizing their amateur status. So that's what you should be doing, essentially. So this case is important to the states because the Supreme Court could ultimately hold that, or if the state, let me put it to you this way, if the Supreme Court rules in favor of the students and against the Ncaa, they'll essentially be saying that the Ncaa has less authority to regulate student athlete pay than the Ncaa thinks it has. So if the Ncaa can't regulate student pay as much as they think they can, who can? Well, the federal government and state legislatures. So what you can see happening is state legislatures passing laws to allow students to receive more compensation to attract students to come to school in their state. California, in fact, has already passed one of these laws that allows students to receive money for their image and likeness. I'm sure the Ncaa thinks that this violates the rules. So as someone who does not care that much about college athletics or athletics in general, think about this case from this perspective. Isn't it odd that a private association gets to decide the pay of an employee, essentially? I mean, imagine if NCSL decided what all state legislators would be paid. Isn't that strange? So that's the kind of odd and unusual context that this case comes in. So the last case I'm going to talk about is Mahoney Area School District. This is a weird, funny, and sad case. So those are reasons enough to talk about it, right? But why I bring it up is not just those. It's that this case really involves preemption by the First Amendment. We don't tend to think of amendments like the First Amendment or the Fourth Amendment or the Second Amendment as being preemptive. But if state law violates the First Amendment essentially preempts it. This case also doesn't directly involve a state statute, though it could. But like I said, it's preemption of a state policy, if you will, or a school district policy via the First Amendment. The other thing is this case is an interesting illustration of the interaction between case law and state statutes, which is what I'm going to talk about next. The issue in the case is very, very simple. May a school discipline a student for off-campus speech? This is a very high school case, as the title says. So the young woman in this case didn't make the varsity cheerleading team. So on a weekend on Snapchat, she wrote a long rage using the F word multiple times in regards to school, in regards to cheerleading, in regards to everything. Within minutes, school officials found out that she'd written this message on Snapchat, and she was, not only could she not be on the varsity team, she was kicked off the JV team for a year. She sued, she said, I had a First Amendment right to speak off campus. I cannot be disciplined for speaking off campus. So here's the state hook. Every single state has an anti-bullying statute. Some states, but not all, explicitly allow schools to discipline students for off-campus speech. But even if a law doesn't explicitly allow schools to discipline for off-campus speech, sometimes the circuit courts by case law have said it's okay. Just to give you an example, the North Dakota bullying statute does not say whether or not North Dakota schools can discipline off campus. But the Eighth Circuit, in a bunch of cases involving Missouri, said, yeah, it's fine. Schools can discipline for off-campus speech. So here in 1969, a young woman who I happen to have met, Mary Beth Tinker, wore an armband protesting the Vietnam War, and the school disciplined her. And the Supreme Court said, look, if her armband wasn't causing a disruption in school, she can wear it. She has some free speech rights in campus. What the court has never decided is whether or not free speech rights apply off campus. And I should also mention this, if the speech on campus causes a disruption, then the schools can discipline. So the Third Circuit said, we don't think that Tinker should apply to off-campus speech. So students should have an absolute right to say whatever they want off campus, and the school shouldn't be able to discipline. And the Third Circuit said this basically because the Third Circuit said, look, once kids are off campus, they're kind of out of the students' control, or the school's control. So they can't, discipline students for reacting negatively to speech. And so all this to say, the Third Circuit said, no, the student cannot be disciplined because her speech happened off campus. So this gets me to my last polling question. My last polling question is this: who do you think should win this case, the student or the school? In other words, should the school be allowed to discipline this student, in which case the school wins, or should the school not be allowed to discipline this student, in which case the student wins? So a couple of interesting things about this case as you vote. I told you that most states, all states have bullying laws, but this incident doesn't exactly involve bullying. A lot of these cases involve students saying, obscene things about other students. This one was her talking more generally about cheerleading and study hall and whatever. The second interesting thing about this case is that there's no coincidence that it came out of Pennsylvania. As Susan mentioned, I worked for the National School Boards Association for a long time, and there's a very active ACLU in Pennsylvania that has been pushing this issue for a decade. They're over the moon that the Supreme Court has gotten involved. And the last point I'm going to make before Susan tells us is this: you got to keep an eye on how Justice Roberts votes in this case, and I'll tell you why. So a couple years ago, maybe 2 or 3, Justice Roberts gave a speech and he said, I am the biggest defender of the First Amendment on the Supreme Court. Now imagine if he'd given a speech saying, I am the biggest defender of gun rights. I am the biggest defender of the right to life. I am the biggest defender of any other controversial issue. People would have been up in arms and livid with him. But it's so well accepted that the Supreme Court loves the First Amendment, liberal justices, conservative justices, that he can say that without any controversy at all. But to my knowledge, and I'm probably wrong about this, but to my knowledge, I only know of 2 times that the Chief Justice has so-called voted against the First Amendment. And by that, I mean that he voted to say that a limitation on speech was okay. In general, the Chief Justice thinks there should be no limitations on speech. People should be able to say and do whatever they want. One of the 2 cases I know about where he said a limitation on speech was okay, the case from about 15 years ago, it was the Bong Hits for Jesus case. This kid unfurled a banner it was when the Olympic torch was coming through Anchorage, Georgia. He was standing outside school, so it was at a school event. He unfurls a banner that says "Bong hits for Jesus," and the school disciplines him. And the Chief Justice basically says, "I don't know what 'Bong hits for Jesus' means, but it sounds kind of shady, and I don't think you should really be able to say that at school." So it's, like I said, it's one of the very rare times the Chief Justice has said less speech is okay. So Susan, where do the sympathies lie with this crowd? Is it with the school or the student?
Well, we have a 67% to 33% in favor of the student. The student should not be allowed, or the school should not be allowed to discipline students for off-campus speech.
I love it. Very interesting. I'm not, that actually doesn't surprise me. Okay, so that is the conclusion of my remarks. So I'm happy at this time to take some questions. And I can try to find the chat box, or if there are some questions, you can read them to me.
I've got a question for you, Lisa. So
Okay.
has the court accepted any interesting cases for this to be heard next term that impact states?
Yes, absolutely and unequivocally. So let me back up and say the Supreme Court's term essentially goes from October 1st till about June 30th. So all the cases that I've talked to you, Rutledge was decided. It was decided maybe 2 months ago. All the other cases that I talked about are going to be decided between now and the end of June. But by the time the court hits February, it starts accepting cases for the next term. So the next term starts about October 1st. So the court just this week accepted 2 really interesting cases for states that will be heard next term if they aren't mooted. So the first case involves public charge. Basically, through 1999, if you were a lawful permanent resident and you wanted to become a citizen, well, actually, let me back up. Since the 1800s, if you wanted to become a US citizen, one of the factors was, are you likely to become a public charge? So since 1999, if you were a lawful permanent resident and you wanted to become a citizen, the court would look at whether you were likely to use cash benefits like Medicaid, Social Security, stuff like that. Trump administration said, no, we're going to look at a broader range of benefits. So if you want to become a citizen from a legal permanent resident, we're also going to look, were you likely to have used housing assistance? Were you likely to have used food stamps? And so the question is, again, it's just one of these agency actions because it's the agency that changed this definition of public charge, which isn't defined in the statute. The question is whether this change was arbitrary and capricious. And the lower court said, yes, it's arbitrary and capricious because, had Congress wanted new immigrants to not receive any benefits at all, what Congress would have done is it would have explicitly said, these are all the things you should look at in the public charge definition. So like I was saying, there's a possibility this case will be moot because the Biden administration, I'm assuming, and I think he's taken steps in this direction, will want to probably go back to the 1999 definition of public charge. So the second case is also another one of these federal government, Biden and Trump have sort of 2 different ideas about how this issue should be handled. The exact issue has suddenly skipped my mind. It was that's not Medicaid waivers. Susan, do you remember what it was? Public charge, and I can't think of it. Ask me another question, I'll get back.
Okay. All right, so another question that we have here is, do you think Justice Breyer will leave the court soon? And if so, who do you think President Biden will nominate to fill his seat?
So as soon as Biden won the election, the articles about Justice Breyer retiring started. So Justice Breyer is 82. He's one of the court's more liberal-leaning justices. And here's the thing. If he was to leave in the next 2 years, President Biden would almost certainly be able to get his replacement through because there need to be 51 votes in the Senate, and there almost assuredly are. So if Justice Breyer waits any longer, the Senate could become more Republican, which could make it harder to leave, even if Biden wanted to replace him. I think the dilemma for Justice Breyer is that he deeply likes being a Supreme Court justice. He's extremely engaged. He appears to be physically and mentally more than able to do the job. On the other hand, he saw what happened to Justice Ginsburg. I mean, we all saw that, and he's not much younger than she is. In terms of replacing him, so President Biden said that he was going to nominate the first female Supreme Court justice who is a Black woman. And there are a number of Black women whose names are being thrown out, but there's one that gets to the top of the pile every single time. And it's Judge Jackson Brown. So she's about 50 years old. She's currently a circuit court judge in DC. So she's a federal trial court judge. So here's what people think is going to happen. Merrick Garland is going to become the AG. His spot is going to become open. So what President Biden is probably going to do is he's going to elevate Judge Jackson Brown to Merrick Garland's seat. And then when the Supreme Court vacancy comes, he'll nominate her. Now, I will mention that I think that Justice Roberts was a district court judge in the DC court system, but he wasn't an appellate judge. So there's no requirement, of course, that Judge Jackson Brown become a circuit court judge, but she is just the most likely pick based on her age. And she's got the right pedigree, Harvard, Yale, that. So all eyes are on her. She may even have Secret Service protection already.
All right, that is very interesting. I know that there's always a lot of intrigue around who will be the next nominated person to the Supreme Court whenever there is a vacancy. So thanks for shedding a little bit of light on that. I have one last question for you, and that is, what do you think, if anything, will come out of President Biden's Commission on Supreme Court Reform? And I know this has to maybe do a little bit with adding additional justices, reforming the process, all of that.
It's a great question. Or I should say, President Biden has only started to make a few nominations. He's promised there'll be bipartisan experts, and the people that he's picked so far seem to meet that criteria. To be blunt, because we don't have hours and hours to talk about this, I think that this is kind of how I've looked at this. Any change to the Supreme Court would have to be done legislatively, right, through Congress. And I think the best change, the best idea out there is the 18-year term limits for Supreme Court justices. That way, every president would be replacing a justice every 2 years, okay? I think everyone kind of, well, maybe not everyone, but I think most of you agree that that's a pretty good idea. Some controversy over whether that would have to be a constitutional amendment. My feeling it probably would have to be a constitutional amendment. Other people disagree with me. Let's just assume that that's the best idea and it rises to the top, but it still has to go through Congress. So you have to get 60 votes essentially to do some court reform. And the Republicans are pretty happy with the way the Supreme Court is right now. So I really struggle to see, no matter how good the ideas are, 60 votes to come out of whatever the commission sort of does. So that's a very cut and dry kind of answer. Like it kind of goes to the end point rather than talk about the work the commission does, the good ideas they might generate. I just don't think there'll be congressional support for whatever they come up with, is my bottom line.
Okay, thanks so much, Lisa. So that concludes, oh wait, we have one more question. Hold on, let me pull it up real quick. This is actually a session question or an evaluation question that I was asked to have you guys do. So before you log off, please take a one-question poll that can be found below the video player entitled Session Evaluation. The results are anonymous and will help us plan future programming. And while you are doing that, I want to thank everybody for attending today's program. Hope you guys learned a lot about how we work here at NCSL with our state and local legal center, Executive Director Lisa Sorinen in filing cases before the Supreme Court. Hope you found her presentation interesting, and we welcome you back to any of our future programs on the Supreme Court. And with that, I will thank you all for tuning in and have a great weekend.